Good evening. This is John Milburn, Laws 19038, Planning and Environment Law. This is week 7, and we're dealing with environmental impact assessment. I apologise in advance. My voice is failing me tonight, so I may struggle to get through tonight's session, but it will be brief. When considering environmental impact assessment, think about the purposes for the assessment. And I could suggest that there are 4 reasons. The first is to inform decision makers and the public about the predicted outcomes of a proposal. But bear in mind, of course, that ecological sustainable development requires consideration of not just that which is to do with the environment, but also matters that relate to social and economic outcomes. So an environmental impact assessment requires the report writer to consider the predicted environmental, social and economic outcomes of the proposal. That's the first thing. The second is that the report writer should consider how the impacts will be managed. The third is to identify what conditions, if any, should be placed upon the approval. And fourth, and this is very topical, to identify ways to monitor the predicted and then the actual impacts. And that may be through a number of ways. One is to implement an auditing regime to ensure adherence to the approval and conditions. And another, through recent legislation, is to create essentially a security bond. Now, when it comes to considering an environmental impact assessment regime, you need to consider the Commonwealth and the state regimes, and it is possible and very common for both regimes to apply to a single proposal. Both Commonwealth and state require, in appropriate circumstances, an environmental impact assessment, but bear in mind that under the bilateral agreement regime and the cooperative arrangements between federal and state, the Commonwealth will often delegate the task of the assessment to the states, and but otherwise have involvement in the approval process. If you look at the YouTube clips involving Phil Jeston, environmental scientist, I think you'll find that he explains the process very well, both from a theoretical but also practical perspective, which is very important. Okay, so let's look at EIA from the Commonwealth perspective. You'll come across the term controlled action, and a controlled action is essentially one where approval is required. Have a look at Part 3 of the Act in that regard. And the approval will be required from the Commonwealth Minister in circumstances where the proposal is one where it is a matter of national environmental significance, or another which involves Commonwealth land. So they're the threshold questions. Is it a matter that involves significant impact on a matter of national environmental significance, or is it one that affects Commonwealth land? If so, the proponent must consider whether the proposed action needs to be referred. And if it is referred, it's referred to the Australian Government Minister for the Environment, and the Minister must decide whether the assessment and approval is required under the EPBCA. I mentioned the bilateral agreement regime. If it's a state matter, then the State Coordinator General may declare a large-scale development as a coordinated project, and that is done under the State Development and Public Works Organisation Act of 1971. Now, if so declared, special procedures apply with respect to the progress of the development application. If it is approved, like if it's declared a coordinated project, that's the terminology we use at the state level. as opposed to the controlled action, which is the terminology we use at the federal level. And it is possible to have something which is a coordinated project without becoming a controlled action. It won't be a controlled action if there is no trigger. And we talked about the triggers: national environmental significance or Commonwealth land. In other words, the Commonwealth Minister may not declare it to be a controlled action under Section 75 of the Act, even though it is a coordinated project under the state legislation. To explain the process, it might be best if I share the screen. I'll do that now, and you'll see a flowchart that I have drawn from the Queensland Government Department of State Development website. The first thing is the proponent must consider referring the project to the Australian Government. That's if it's to be a controlled action. May not happen, as we indicated. At a state level, which is in the blue, you'll see there's a pre-lodgement meeting followed by the application itself for a declaration as to whether or not this is going to be a coordinated project. Now, I'll assume that the Coordinator General does declare this to be a project which is coordinated. Then the draft terms of reference are prepared. The final terms of reference issued to the proponent. So that's the Coordinator General preparing the terms of reference for the EIS. It's up to then the proponent to prepare the draft EIS, which is publicly released, and the Coordinator General and the public may make submissions in relation to that draft. The Coordinator General may in fact ask for further information and request a revision of the draft EIS. Once that has been through the process of negotiation and it must be publicly notified, the Coordinator General then will accept a final EIS, will release a report, and it may be that the Commonwealth Government is involved in final approval. So they are the basic steps in relation to that process. The materials that I've written in week 7 are extensive. You have some excellent videos to refer to. If you have any questions, please ask through UCrew, and I will continue to provide answers to the weekly problems. But if you have a contribution that you wish to make, I encourage you to do so. All the best. Sorry, just a word about the assessment. Due at 11:45 p.m. tonight. If you need an extension application, lodge it by that time. I won't accept any applications for extension after tonight, but you can still lodge the application or your paper late. It's just that you will suffer 5% per day penalty. Bear in mind there is a final cut-off, which is Saturday week. I won't accept any work after 11:45 p.m. on Saturday week. Beyond that, I would encourage you to submit the work as soon as you can. All the best.